All right. Good afternoon, everyone. Thank you for joining us this afternoon for this month's CJR Scholarship Workshop, Breaking the Backbone of Unlimited Power 2, Clarifications and Suggestions, featuring Professor Zamir Bendan from the Temple University Beasley School of Law. I am Kenitra Brown, the staff attorney and director of engagement for the Deason Criminal Justice Reform Center at SMU Dedman School of Law. We are a nonpartisan policy, research, and advocacy center. We use a stats and stories approach to smart, sane, and sensible criminal legal reform with the focus on three major research areas: Sixth Amendment rights, with the right to counsel as the crux of our expertise, and an increasing focus on pretrial due process; STAR justice, our small tribal and rural criminal justice events; and prosecutorial discretion with a specific focus on screening and charging processes. For our returning audience and those of you who may be new to the Deason Center CJR workshop series, these workshops provide a virtual forum for academics and researchers to share criminal justice works in progress with an audience of academics, practitioners, or other stakeholders. We believe the unique format of this workshop series with stakeholder engagement from across disciplines and perspectives provides richer perspectives and discussions across topics. Today's speaker, Professor Zamir Bendan, joined the Temple Law faculty this fall. His research interests and emerging scholarship lie in the intersections of criminal law, race, and the law and American history. He earned his associate's degree from Rockland Community College in December 2009, his bachelor's degree from Baruch College in May 2012, and his law degree from CUNY School of Law in May 2015. While in his first semester of law school, he served as the interim director of forensics at Rockland Community College, coaching the debate team to success within its respective league. And in his final year of law school, he served as the president of his moot court team. After graduating law school, he joined the Legal Aid Society in New York City as a staff attorney in the Bronx criminal trial practice. Over the next 4 years, he represented hundreds of clients on both felony and misdemeanor matters. In 2017, he was the founding member of the Black Attorneys of Legal Aid Caucus, BALA, an amalgamation, of over 100 Black legal aid lawyers that advocates for racial justice both within and without the Legal Aid Society. He served in BALA leadership for nearly 5 years. In 2019, he joined the Community Justice Unit, where he provided wraparound legal services to participants and nonprofit organizations that do cure violence work. That same year, he also began an adjunct professorship in the Black and Latino Studies departments at Baruch College, where he would teach for 5 semesters. He's taught as an adjunct at CUNY Law's first year lawyering program, and he also created a practitioner course through the National Association of Public Defense called Warrior Motion Practice, teaching a methodical approach to creative motion writing as a means of addressing social wrongs. Before I pass the presentation over to Professor Bendan, please note that we are recording this presentation, but the recording will only be available to registrants and attendees. So please feel free to place respectful comments, questions, or clarifications in the comments section as this presentation goes, and we look forward to a lively discussion at the end of his presentation. Please welcome Professor Bendan. Zamir, sorry. Are you muted?
Yes, I am.
Yeah, there we
Naturally.
go.
So yes, hi everybody. Zamir Bendan, new professor at Temple Law School. Thank you, Kenitra, for that lovely introduction. So this article is going to be a follow-up to an article that I already wrote called "Breaking the Backbone of Unlimited Power," and this is an article that I wrote calling for Congress to abolish absolute immunity for prosecutors in civil rights lawsuits. Um, I know that you all got the articles. Some of you may have had a chance to read it, some of you not so much. What I figured I would do is I would present this article just to go over it for folks who might not have had an opportunity to read through it. And then after I present it, then I'm going to go ahead and talk about some issues that were both raised to me and things that I thought of that I would want to address in the follow-up piece. So the follow-up piece as of this moment is really just in the brainstorming stage. I'm trying to figure out what I want to say afterwards. I have some ideas of some things that I want to say, but they're not necessarily so refined. So breaking the backbone of unlimited power, which was the article that I wrote, or co-wrote, I should say, again, was a piece about ending absolute immunity for prosecutors. Now, the presentation that I did on the article, I would start off with two anecdotes, one about somebody named Chris and one about somebody named Rob. And so Chris was a person who back in 1989 was arrested and charged with a homicide that he did not commit. And in 1992, he was convicted and imprisoned from 1992 to 2021. And then in the year of 2021, he was finally released when it was discovered that the prosecution hid evidence that was favorable to his case. They hid evidence regarding proof of his whereabouts, that he was not there at the time that the murder took place, and also a witness who had testified that somebody else had committed the shooting. And so this is favorable evidence that the prosecution hid. And then there was an individual named Rob, who was a client, not with the Legal Aid Society back when I was an attorney there, but was with an alternate provider. And he and two other people were charged with robbery in the third degree. And they were locked up in Rikers Island, the most notorious jail in America, from June of 2016 to September of 2017, awaiting trial on this robbery case. And this was a one witness robbery case. So it was just a person claiming that they were robbed. This wasn't a situation of having video footage or DNA evidence or anything to that effect. The entire case rested upon this one witness making a claim. And so from June of 2016 to September of 2017, they sat in jail awaiting trial. And then when the case went to trial, or was supposed to go to trial in September of 2017, the prosecutor was forced to dismiss the case because the complaining witness had died in August of 2016. And so these clients sat in jail for over a year on a case that the prosecution knew was not going to trial, pretty much for the purpose of trying to get them to take a plea before the prosecutor's hand would be forced. Now, many people who've heard these stories or have heard stories like these would think that this is unconstitutional and that there's got to be some way to hold them accountable and be able to sue prosecutors. But unfortunately, under the current state of the law, neither of them can sue the prosecutor because of this doctrine known as absolute immunity that the Supreme Court invented in 1976. So what inspired me to write this article was the uprisings that had occurred in 2020 with George Floyd and the national and international call for accountability and racial justice. And there was a lot of focus on policing, ending qualified immunity, holding police officers accountable, and the like. And I thought that the conversation was necessary, or the focus on policing was necessary, but I also thought that it was incomplete. And I thought it was incomplete because, first off, if police officers are not being held accountable, the problem does not just rest with police. It rests with prosecutors and it rests with judges, particularly prosecutors, if they're choosing not to prosecute police officers. And then there was a lot of calls for, ranging from criminal justice reform to abolition. But if there is going to be criminal justice reform, then again, we have to look at the players in the criminal judicial system. And I would certainly submit that prosecutors, more than anybody else, have more power in the criminal judicial system compared to other actors. And so if there is a need for criminal justice reform, then there has to be a need for looking at prosecutors and addressing prosecutorial misconduct. And I thought that that particular conversation was lacking. And so that's what I wanted to speak to in the article. And so the article is divided into four sections, if you will, three main sections. First being prosecutorial misconduct and the ineptness of existing checks. So establishing prosecutorial misconduct as an existing issue and showing that the remedies in place to check prosecutorial misconduct pretty much don't work. Then I went through an examination of Section 1 of the Civil Rights Act of 1871, which was the statute that created the modern federal civil rights law. Then I did a critique of Imbler versus Potman, which was the Supreme Court case that created absolute immunities for prosecutors in civil rights lawsuits. And then finally, I conclude and give reasons why Congress, and I focused on Congress as opposed to the Supreme Court overruling itself, since I think realistically speaking, that's not going to happen anytime soon. And so in the first part, I pretty much went through four sections: that prosecutors have immense power, they frequently engage in misconduct, they abuse that power, they exercise the power in racially discriminatory ways, and that the checks are ineffective. With respect to the first one, prosecutors have immense power because they're the ones that decide whether to charge, who to charge, and what to charge. They have complete discretion over whether or not an offer gets to be made. Now, as a person who's practiced public defense, I know that if I have a client, for example, who does not have a criminal record and they're charged with a crime, I need the prosecutor to offer something that allows them to walk away without a criminal record. Because if they don't, then my only other alternative is to go to trial and try to beat the case. And so prosecutors have immense influence over the offer and the pretrial bargaining stage. And given the fact that over 95% of cases end in pleas and pretrial offers and do not go to trial, then in essence, prosecutors have immense influence over how cases ultimately resolve in the criminal judicial system. Additionally, prosecutors have a lot of influence in terms of bail decisions and in terms of sentencing decisions. They give recommendations as to both of them, and or more often than not, judges tend to follow them. The second part of my article pointed out how prosecutors will engage in frequent misconduct. One of the most examples of misconduct, if not the most common type of misconduct that prosecutors engage in, is what we call Brady violations. So where the prosecutor is supposed to turn over evidence that's favorable or that's exculpatory, and they refuse to do so. And that's what happened in Chris's case that I referenced earlier, where there was favorable evidence and exculpatory evidence that was not turned over to the defense. And as a result, they couldn't pursue that defense, and it harmed their case. The third point that I made in the article was that prosecutors exercise their authority in racially discriminatory ways. The statistics have borne out that Black people and white people and non-white people are treated very differently throughout the criminal judicial process. They're treated differently in terms of what recommendations prosecutors have on bail, what recommendations prosecutors have on pretrial bargaining, and what recommendations prosecutors have as to sentencing. And then finally, the checks are pretty much ineffective. The checks on prosecutorial misconduct pretty much amount to criminal prosecutions, disciplinary proceedings, and ethics complaints. As far as criminal prosecutions, they pretty much never happen. As far as ethics complaints, there have been ethics complaints filed against prosecutors, and statistics have shown that even in cases where prosecutorial misconduct is found by the disciplinary committee or by the ethics committee, that it doesn't lead to any punishment. And in the rare instances when it does lead to punishment, the punishment is like a censure or a slap on the wrist. It's not suspension from the bar or disbarment or anything like that. And then as far as disciplinary proceedings by the state in terms of having license removed, again, that doesn't really happen either. And so after going through this, my argument or conclusion was that it's necessary for individual citizens to be able to hold prosecutors accountable, because relying upon the state to do it is not effective. And all of those other measures, the checks that exist for prosecutors, are state measures. And so individual citizens need to be empowered to sue prosecutors and to hold them accountable. But unfortunately, the Supreme Court has foreclosed that with its decision. And so in part two, I dove down into the history and the language and the legislative history surrounding the Civil Rights Act of 1871, which is now, or the first section of it is now, federal civil rights law. And I thought it was necessary to go through that history to show whether or not this idea of prosecutors having absolute immunity has any bearing in the history of the law. And so when you look at the history of the Civil Rights Act of 1871, that takes you to the end of the Civil War in 1865. The United States enters the Reconstruction era, and there is a determined effort by the federal government, particularly the radical Republicans, to integrate Black people into American society. But the problem in the South was that white former Confederates weren't having it. And so efforts to integrate Black people into American society was met with extreme violence, where white people who were former members of the Confederacy were mobbing themselves up into the Klan and to other white supremacist organizations, and were going around slaughtering Black people and were slaughtering white Republicans who were at the time allied with the interest of African Americans. Now, that was bad enough. What made it even worse was the fact that these criminal judicial systems in those states where it was happening was not doing anything about it. There was literally no accountability at the criminal justice level for people who were slaughtering individuals. At the same time, there was the existence of the criminal justice apparatus when it came to Black people allegedly committing crimes against white individuals. And so the federal government, which was under the control of the radical Republicans, was very active in enacting legislation to address that. So they passed the Civil Rights Act of 1866, which was the precursor to the 14th Amendment, which put in place equal protection, due process, and protections for Black people who were then made citizens. And then you had the 15th Amendment and then two other enforcement acts that predated the Civil Rights Act of 1871. Now, specifically with this act, the federal government was looking at curtailing the violence that was going on in the South, and particularly holding the state governments, the state officials in the criminal judicial system accountable for not allowing there to be any justice for people of African ancestry and white Republicans who were being killed off. And so that's the birthplace of the Civil Rights Act of 1871. The point of the Civil Rights Act of 1871 was to hold state officials accountable for the violence that was going on and for not applying the laws equally as they should. Now, Section 1 of the Civil Rights Act of 1871, the operative phrase is any person. It says any person, no exceptions, no exemptions, no preclusions. There's nothing in the language of the section that suggests that any state official should be immune from suit and should not be sued. And then after that, I went into the legislative history and I read the speeches of the Republicans and the Democrats who were debating this particular legislation. And the proponents of the act were crystal clear as to who was to be held responsible: state officials. There was no conversation about immunities, no conversations about exceptions, exemptions, exclusions, nothing to that effect. And particularly, they harped on the fact that criminal judicial officials were not doing anything about it. Criminal judicial officials back then certainly would include sheriffs, it would include judges, and then it would include prosecutors as well. Now, what was also interesting was that the Democrats were uniformly opposed to the legislation. Back then, the Democratic Party was the party of Dixie, but there were three Democratic lawmakers in particular who expressly noted that under the language of the bill, state officials like judges, sheriffs, and ministerial officers could be held liable in federal court. And the Republicans did not dispute this point. As a matter of fact, the person who sponsored the bill was a representative out of Ohio, and he had a reputation for interrupting individuals if he felt that they were misrepresenting the legislation that he put forward. And yet when they made this argument, he sat quiet. So again, more of a suggestion that that was the point: to hold state officials accountable, to give individual citizens the right to hold state accountable, the power to hold states accountable when they violated their constitutional rights. And then, of course, the very fact that the bill passed with that language intact is further evidence that the 42nd Congress rejected the arguments of those Democratic lawmakers, including these three who argued against the Civil Rights Act of 1871. And so it's my conclusion in the article that the history leading up to the act, the language of the act, and the legislative record make it crystal clear that prosecutors were not entitled to absolute immunity, and that no one, in essence, who was a state official involved in the criminal judicial system was to be exempt from suit. And then when you examine the history from 1871 to 1976, when the Supreme Court decided Imbler, the need for a remedy like this was so apparent because the criminal judicial system continued to differentiate between white people and Black people, treating white people one way and Black people another way, with prosecutors making central decisions that ultimately led to that. And so after the end of Reconstruction, white people returned again to start killing Black people. And yet throughout all the lynchings that occurred from the late 1800s to the 1900s, no one was ever held accountable. When the Civil Rights Movement came into being and when the Black Power movement came into being, prosecutors would routinely prosecute the civil rights demonstrators and would prosecute those involved in the Black Power movement, and in essence, let the white people who were committing crimes against them go unpunished. And so to date, this is a necessary, I argued in the article that it's a necessary tool, this federal civil rights statute, as a means of holding prosecutors accountable and addressing some of the disparities that have existed for a long time in the criminal judicial system. So that was part two. Part three of the article then focused on this particular decision, Imbler versus Potman. And one of the things that I noticed when I read the decision was that there was no examination of the legislative history of the Civil Rights Act of 1871, and there was no discussion of the rules of statutory construction, which I found to be rather odd because this was an issue of first impression before the court. The Supreme Court had never decided whether or not prosecutors were immune from suit in the civil rights context. And so that's normally what the Supreme Court does when they're examining an issue for the first time. They talk about the rules of statutory construction, they read the plain language, they read the legislative history, and they make a decision. So the fact that the court didn't do that was suspect. Now, the court's decision, when you read the rationale of it, ultimately boils down to two major points. First, that absolute immunity for prosecutors was well established at common law, and that allowing prosecutors to be sued would have a chilling effect on prosecutors and their ability to do their job. And so the article, in essence, deals with both of those. So as far as the first reason about absolute immunity for prosecutors being well established for common law, that's just not true. It certainly was not established at English common law. At English common law, they didn't have public prosecutors. They had private prosecutors, and then they had justices of the peace, which were hybrids between prosecutors and actual judges. Neither one of them had absolute immunity in English common law. And then in American common law, there was no immunity for prosecutors. America at one point had a mix of public and private prosecutors, but even then there were decisions that noted that prosecutors were not subject to absolute immunity and could not prevent themselves from being sued. So much so that in 1854, there was a case of a public prosecutor being sued, and he didn't even assert a defense that even resembled absolute immunity. Certainly, if such a thing existed at common law around the time that the Civil Rights Act was enacted, he would have alleged it. So the fact that he didn't, again, suggests that there was no such thing. The first case to ever hold that prosecutors could not be sued was by a court in Indiana in 1896, 25 years after the Civil Rights Act of 1871. And then between 1896 and 1925, courts went back and forth on it, with courts in California, Minnesota, Michigan, and in other places saying that prosecutors could be sued and were not subject to absolute immunity. So contrary to what the Supreme Court claimed, absolute immunity for prosecutors was not well established at common law. In fact, it didn't exist at common law at the time that the Civil Rights Act of 1871 was enacted. And then the second reason for allowing prosecutors to be, second reason being allowing prosecutors to be sued would have a chilling effect on prosecutors. The 42nd Congress already dealt with that argument. That's what the Democratic lawmakers were saying, that this would have a chilling effect on judges, a chilling effect on ministerial officers, a chilling effect on sheriffs. And yet, the Congress enacted the legislation anyway. So what the Supreme Court wound up doing is that it resurrected this argument that was defeated and substituted that argument, its own judgment for that of the 42nd Congress instead. And then aside from that, I think that argument is just not persuasive, because you can say that for anybody. Why not exempt police officers and sheriffs? Because they don't have absolute immunity. And we can argue that if a police officer were to be sued, then that would inhibit the police officer's ability to do their job. What about prosecutors acting as investigators? Prosecutors acting as investigators don't necessarily have absolute immunity, and yet that could inhibit them from doing their jobs. What about public defenders? Public defenders, if they could be sued and don't have absolute immunity, that argument could be made that they'd be afraid of doing their jobs, and a whole lot of people would not be entitled to defense. And what's so interesting is that the Supreme Court dealt with a question of whether or not public defenders had absolute immunity in 1984 in the case Tower versus Glover. And the Supreme Court, in denying the argument that public defenders had absolute immunity, said something to the effect of, we don't have the right to grant immunities out of whole cloth. Right, they don't. But that's in essence what they did in Imbler, granting it out of whole cloth because it did not exist in common law. And the argument that, it would have a chilling effect, you can spread that across the board, even outside of the state official context. You can say that if doctors could be sued, that it would impact their ability to do their job. If teachers could be sued, it could impact their ability to do their job. The point of the lawsuit is to give individuals a remedy when wrongs happen and to encourage people to not do things that they ought not to be doing. So after that, then I put Imbler in what I thought was the appropriate context in terms of examining why the Supreme Court decided Imbler in the manner that they decided it. And so in 1968, Richard Nixon became the president. And in the 1970s, there was an effort to bring about, in essence, the war on drugs. And the war on drugs was simply the newest iteration of systems of repression that had existed. And Nixon's own former aides have said this, of having drugs associated with African Americans, having crime associated with African Americans, and then saying that you're criminalizing crime when, as a matter of fact, you're going after Black people. And so the war on drugs became underway, and pretty much preoccupied the American consciousness from the 1970s onwards, definitely in the 1980s and 1990s. And in many respects, it continues to this very day. But what it shows is that there was the system of mass incarceration being primed. The beginning of it really began in 1973 when the prison population began to explode from the 1970s on forward. And the Supreme Court pretty much embarked on a path from the 1970s up until this point of doing two things: of number one, reducing the constitutional rights of those charged with crimes, and number two, immunizing the system and its players from criminal liability. And Embler falls within that second context of immunizing the criminal judicial system and its players from criminal liability. And so in 1976, the Supreme Court decides Embler, which grants absolute immunity to prosecutors, individual prosecutors. In 1985, the Supreme Court raised the bar on selective prosecution claims, claiming that in order for a person to be able to prove selective prosecution, they have to show a purposeful or intentional discrimination. 2 years later, the United States decided McCleskey versus Kemp, which immunized prosecutorial discretion from racial discrimination challenges in the context of sentencing, although it's been expanded beyond that, so much so that racial discrimination challenges have pretty much never succeeded at the Supreme Court level in the criminal judicial context. In 1996, the United States pretty much barred attorneys from getting discovery unless they could make a showing beforehand that the discovery would show that there's racial discrimination happening at the prosecutor's office. Now, of course, the only way you would know that is if you could look at the discovery. So how do you make a showing of something when you can't get the information is beyond me. In 2009, the Supreme Court granted absolute immunity to supervisors and extended it in a host of administrative contexts. And then in 2011, the Supreme Court then extended it to the entire prosecutor's offices as well. So when it comes to being able to hold prosecutors accountable, the Supreme Court has done a fantastic job of shielding prosecutors, the whole office, from any type of liability in the civil context. And so ultimately, I concluded that Congress should end absolute immunity for prosecutors acting as advocates in federal civil rights lawsuits, because doing so would provide some measure of justice and it would have a deterrence effect for prosecutors. Or so I thought. So in terms of clarifications and unanswered questions, here's some of the things that came up both when I started having conversations with people about the article and then things that I thought of on my own. And so number one is, should prosecutors have qualified immunity, since I'm arguing that they should not have absolute immunity. I specifically left the qualified immunity question open because I wanted to focus on absolute immunity. I thought that the idea of prosecutors not being sued at all under any circumstance was just problematic. But then, of course, if I'm proposing this as a solution, then the question is, how effective of a solution is it? And so if prosecutors have qualified immunity, well, how hard is it to sue somebody when they have qualified immunity? You look at the jurisprudence when it comes to police officers, and we see it's still hard to sue police officers when they have qualified immunity. And so with regards to the first question, I'm leaning towards a no, at least certainly the way qualified immunity is the state of qualified immunity jurisprudence today. But again, there's questions that I have as to that. And I think on a related note is the question of regulating discretionary decision-making, because one of the biggest issues that was brought up with my article was the fact that with the progressive prosecutor movement and some prosecutors looking to hold police officers accountable, if you now have it open where prosecutors can be sued, then you can have prosecutors getting sued for prosecuting police officers, you can have prosecutors getting sued for prosecuting corporations and things like that. And so it could have the perverse effect of, in essence, empowering those who already have the power to then shut down prosecutors who attempt to hold them accountable. And so there's questions of like, how much, if discretion should be touched at all, I guess, and then if so, then to what extent should prosecutors have leeway for making discretionary decisions? Because That, of course, I would not want to have happening, of prosecutors being sued for trying to hold officers accountable or for trying to hold corporations accountable. Another question I'm thinking about is, should there be any circumstances where a prosecutor should be made amenable to suit for not prosecuting someone? And I'm thinking this within the context of police officers, of not prosecuting police officers who engage in or who kill unarmed Black people or who commit serious acts of violence against unarmed Black people. Of course, there are different ways that that could be stretched around too. So trying to think of how to fashion something that would perhaps allow it in the police officer context and not allow it to potentially get abused. I think the fourth one is another big one that that was raised to me, which was about creating a deterrence effect. I think allowing prosecutors to get sued would give some measure of justice to the individual, but the idea of it having a deterrence effect, I don't think as of this moment is realistic, because even if prosecutors were to be made amenable to suit, there's always indemnification. A lot of times the state, the city is going to reimburse prosecutors just like they do it for police officers. And so I thought, well, then that's easy. You just take away indemnification. But then if that happens, then you take away the incentive for a lot of lawyers to sue in the first place, because chances are prosecutors aren't going to have the money on their own. And so now there's kind of that discussion of like how to create a deterrence effect while at the same time not removing the desire or the incentive to sue. And then the last two are kind of just other things that I'm grappling with, possible standards and burdens. So if I'm going to say that prosecutors should be made amenable to suit, then how am I going to classify misconduct? You know, discretionary decisions versus Brady violations versus suborning perjury, you know, things to think about. And then finally, dealing with other Supreme Court obstacles, such as its terrible equal protection jurisprudence, because that by itself is a problem that's wholly independent of prosecutors entirely. So these are some of the things that I'm thinking about. I don't know if these are all going to be appropriate for one article. They might be 2 or 3, I don't know. But that's kind of what I'm grappling with and some of the things that I'm thinking about. And so with that, my presentation portion is done. So I am willing to hear any questions, comments, thoughts, concerns. And then also if there's anything, you know, questions, if you read the article and there's a question that I haven't raised here that you think is worth talking about, I'm happy to hear that too.
All right, before we get into that, Leo's first. I am going to ask everyone if they'd use their hand raising function, so that we can keep an order, and I'll place the order in the chat if necessary. I see Leo first. And also, if you can, no pressure, but if you can, while we're in the discussion session, would you mind turning on your cameras so that we can see you? But if you can't, no worries. You can still ask questions in the chat or with the audio function if you want to ask a question. And we'll keep going on the questions, comments, and thoughts with my first moderator's privilege of saying I truly, truly enjoyed the paper and the presentation. So I can't wait to hear the discussion. And we'll start with Leo because he's the first person to raise his virtual hand.
Hey, thank you. Very great paper. I really enjoy reading that. So I have 2 questions. My first question is, why do you think we almost suddenly lose the support from liberals from the Supreme Court level when we deal with immunity issues? You know, several cases you elaborate in your article. You know, Vanda camp, that was I think 9-0 with, you know, Ruth Ginsburg, Breyer, and I think Kagan or not Kagan, you know, all sign up on that. And I can name, you know, 2 or 3 cases, you know, plaintiff lost the grade from the liberal side on this issue, and that is in the civil rights area. That is very different from the abortion, LGBT right, where you basically know where they stand. What is your take on that? Why we have lost grades from liberals on this really urgent issue? And my second question is, you know, whenever we talk about immunity issue or trying to limit the scope of immunity, there is I would say classic pushback is, oh, wait a minute, immunity can only bar damages. It doesn't bar injunctive relief. Why you really want people to pay? Why not just have the court to render very harsh injunctive relief to those individual defendants? Why cannot that be sufficient? So what is your comeback on that? Thank you.
Okay, thank you. Those are great. Why support liberals? That's a fabulous question. I mean, it's a tough one because you look at the positions that they take on other criminal justice issues, and it seems to align with, ideas of rights for defendants and things like that. And this absolute thing on prosecutors just doesn't seem to align with that. I think the conversation about prosecutorial misconduct is a relatively new one. There's a growing awareness of it, but I don't think it's anywhere near as wide as it needs to be. And so I think it really comes to a matter of there needing to be, I think there's a lot of scholarship in the area, but more awareness, I think, on the general public side as to the issues of prosecutorial misconduct. And that needs to find its way in a Supreme Court brief. It needs to find its way in Supreme Court arguments so that the idea of absolute immunity can be rethought. I think just the concept of immunities generally just needs to be rethought. In terms of injunctive release, why can't they use injunctions? I think part of it has to do with, who's bringing the lawsuit. Injunctions don't really solve the harm that was done. So if something was done to me and the injunction says that this particular action, let's say it can't be done again, but it still doesn't remedy what was done to, the individual. So I don't think injunctions solve that. And then, I'm not going to profess to know a whole lot about injunctions, but I think bringing about an injunction, it's easier said than done. I think about, for example, the city of Los Angeles versus Lyon, where he sought an injunction after he was choked, pretty much to unconsciousness. And the Supreme Court said he didn't even have standing unless he could prove that every cop would have done it and that he's going to be choked at every time. So the standard of getting an injunction in the civil rights context is very difficult. But then again, getting remedies in the civil rights context in any area is going to be difficult.
Thank you.
Are there any other hands before I take moderator's privilege on a question? Oh, I think I just saw Elliot unmute, but I don't know if that means he's. All right. Jessica, is your hand up or are you asking, I'm sorry, it's not clear. Sorry, no, it's not. Elliot. Oh, sorry. I can't tell.
Jessica, you gave the
Yeah.
applause emoji, the applause thing, yeah.
The hand is up. So
It's my first day back for the semester and I've been having tech issues all day. So you can all laugh at me. My students have been laughing at me all day. I had a couple of just, excellent article. I had read it actually before I even saw this that you were speaking today. So thank you for an excellent, really a nice dissection of the issue. One of the questions I've always had about Imler itself is this analogy that the court sort of so happily drew between prosecutors and lumping them in with sort of judges as opposed to any other kind of actor like a police officer. And I'm wondering, if you could speak a little bit about that. Do you think it has to do with the fact that so many judges are former prosecutors and so there's this sort of internal alignment, or do you think there is something else? What do you think about that sort of comparison? That's one of the questions I have. I have a bunch, but let's start with that.
I definitely think that a lot of judges seem to think prosecutors and judges are both committed to this idea of justice. And it's a perception that you can have if you take out race, class, gender, and kind of the things that tend to color supposedly objective things. As far as many judges being prosecutors, I'm sure that plays a role in some way, shape, or form. I don't know if any of the Supreme Court justices per se were former prosecutors. But as a person who was a public defender, I definitely see the relationship between prosecutors and judges and the affinity between the two. So.
And if I can I see someone else has their hand up, but there's a separate and unrelated question that I have that I personally been struggling with in my own work. one of the issues with prosecutorial misconduct is, for instance, take a Brady violation. Brady violations come in lots of different forms, from intentional destruction of evidence to sort of that inadvertent, like, holy moly, I have too many cases and I didn't realize what the heck was in my file, or I didn't realize how material it was, or I didn't realize how important it was. And so, I've been thinking a lot about what does it mean to hold prosecutors accountable? What would that look like? And how do we deal with the more, obviously the blatant, horrific kind of instances of prosecutorial misconduct are one thing, but what about the instances of misconduct that fall more into sort of ethical violations, or just failing to kind of understand or appreciate what they have in their file, even though it can cause tremendous damage?
So, when I read, the statute, the legislative history, the emphasis for the legislators in favor of the law was on the blatant misconduct, the obvious misconduct, and not necessarily the good faith mistakes that people make. And this is kind of, where my question is in terms of fashioning standards, like what would a standard look like of a prosecutor being sued? I think in a situation where it's, clearly an oversight, due to voluminous paperwork or whatever the case is, that's not going to be treated the same as the prosecutor who destroys evidence. But then also trying to think of ways in which that can be truthfully determined. Because of course the argument will always be, well, it slipped my mind, I didn't see it, or what have you. And, sometimes it could be a question of, okay, well, the individual prosecutor might not have known about it, but had you had a legitimate system in place to make sure that any evidence gets turned over, then this would not have happened. And so that's all of that are things that I want to think about. But I think just generally speaking, if we're talking about good faith, innocent mistakes, that would be outside of the purview of a lawsuit. Whereas if we're talking about, the seriously careless mistakes, and then of course the blatant misconduct, then that would be actionable.
So my question, if I can jump in, first of all, I thought your presentation was excellent, and I really learned from it, even though I've been doing this law.
Thank you.
Cases in this area for 40 years now. The question I have pertains to when a prosecutor prosecutes a case that they know is barred by clearly established law. They wouldn't even have good faith immunity in that situation, or they shouldn't. And yet that happens. And in the First Amendment area, it happens. I've got two cases right now where the prosecutors prosecuted cases against individuals, protesters, who are engaged in First Amendment activity, clearly established protected expression. And they prosecuted for several years. Because probable cause had been rubber stamped by some magistrate judge, some municipal judge, the officers are claiming that they're free from liability. And I don't think they are, for other reasons, but why should the prosecutor be able to then continue to prosecute that case and have immunity, even though the prosecutor should know better than the officers that prosecution violates clearly established law?
Yeah, that's an excellent question. I mean, it's up to me, they should be able to. Right. I mean, I think the issue of the judge rubber stamping the probable cause is definitely an issue. And I mean, honestly, with respect to judges, I don't think judges should have absolute immunity either. They should be sued as well. But that's a whole separate conversation. But I think it's a tough one if the judge rubber stamped it. But if the argument can be made where I'm just brainstorming at this point, but perhaps if the argument can be made where, a defense attorney can find case law that's like squarely on point, they send it to the prosecutor continues even though the case law is squarely on point. Like maybe that would be a situation where, the prosecutor could get sued regardless of, a judge rubber stamp. But the judge rubber stamp complicates things.
Yeah, the judge rubber stamping the probable cause, even if it's a municipal judge, not the judge administering the criminal case, but some judge somewhere says, yeah, that's the arrest is lawful. You can go ahead and do it. But I was thinking this is a way to whittle down or whittle away at prosecutorial immunity when a prosecutor is prosecuting a case that they know or that clearly established law prohibits. Surely that prosecutor should have absolute immunity from being able to do that.
I mean, I agree. I mean, I don't think they should have absolute immunity, period. But yeah, I definitely agree that that should be actionable.
Thank you.
All right, I don't see a hand, so I'm going to take moderator's privilege while if anyone else has a question, gets that together. So my question, or rather my comment, it's actually starting from the legislative history portion of the paper. You mentioned, well, you start with the premise that this Congress has to make this move, right? Because courts are basically complicit in this matter. It's unlikely that courts, because they wholesale created this doctrine, are unlikely to overturn it. And then with this particular Supreme Court, I also think it's difficult to overturn it. So in the legislative portion of the paper, you mentioned that Congress created its own Enforcement Act, which then led to the amendments in the Constitution. But that Enforcement Act went through basically to make sure that state operators were not suing federal operators in state courts. So I'm wondering, when you say that Congress should do it, if the next part, the next part of your research agenda, the next part of your paper includes barriers for Congress to address this in an Enforcement Act, right? Because the act itself is already clear about the intent, about the fact that they never intended to give prosecutors immunity, but now they've got to contend with all of this judicial doctrine, right? And what that looks like. Is there an analogous situation where Congress has taken something back that's got all this judicial history, and kind of look at the barriers to Congress actually passing or actually putting an Enforcement Act back into place that acknowledges that we already contemplated this. The Supreme Court substituted its judgment into our purview in this area, and now we've got all of this judicial history, or all of this precedent that's turned our intention on its head, right? And so how do we flip it, and what do they have to contend with getting through that judicial issue? There's a very small comment about that in the ethics portion of holding. So
I mean, the irony about it is that the Supreme Court, whenever they've dealt with qualified immunity and absolute immunity, they've always used the same refrain, which is, we read these immunities unless Congress expressly says otherwise.
Right.
Or we consider these immunities to be part of it unless Congress changes it. And so, as far as I'm concerned, Congress should just change it. I think the idea of turning to the Supreme Court on the issue of prosecutorial immunity, given how the Supreme Court has voted on it, I mean, Embler was a unanimous decision. And the recent Supreme Court case, Van Camp versus Goldstein, unanimous decision. And so looking to the Supreme Court to change it, I don't think is going to happen anytime soon. Not that Congress is going to do much of anything worthwhile either, but I think the bigger chance is with Congress than the Supreme Court.
I agree there. I don't think we're going to get anything from the Supreme Court, and I may have missed it, so apologies. And then maybe this is for everyone else. Can you give a little bit of the facts into the Van Camp? Because I figured that the Embler decision was, the fact is, I think it went that way because the prosecutor attempted to disclose, in the facts, they ahead of the, habeas suit and all that they attempted to disclose that their case was that their case against Potman was crumbling. He was never the person who did it, blah, blah, blah. And so maybe they were trying to give some credit to the prosecutor for acknowledging on his own that his witness and all these other parts of his case did not sustain a conviction against Potman. And so they were trying to, but instead what they put in the record was absolute immunity for anyone, even who didn't make that good faith that good faith decisions. I'm like, what are the facts in Van Camp?
I
What
don't,
makes that
I don't think
unanimous?
Imber turned on whether or not they're acting in good faith or not. The Supreme Court literally just said they cannot be sued.
Yeah.
And they cannot be sued for all of these reasons. Van Camp, I believe, was a situation of a Brady violation. I honestly don't recall the facts offhand, but I know that they in essence tried to sue the supervisor, and they tried to sue other administrators as well within the prosecutor's office. And the Supreme Court said you can't, because in essence, the rationale for Imbler extends here. So whether or not they acted in good faith or not, the court really didn't care. They just said you can't sue prosecutors.
All right. So then if I mean, I'm gonna keep talking because I don't see no hands. But so then I guess as you're working through this, are you like, okay, so your bid is with Congress and you have some doubt about Congress. What does it look like? I mean, it's not overturning, right? It's literally just enforcing what they've already.
Well, I mean,
What do you think that looks like?
Congress would, in essence, be overturning the jurisprudence by saying that, you know, if they're clarifying the Civil Rights Act of 1871 to read out the immunities, then it would be overturning the Supreme Court cases that say that they do have immunity. But if the Supreme Court abides by what it says, that Congress is the one that makes the decision about what immunities are and aren't, then ideally the court would abide by it if in fact Congress did redefine it.
I see a hand from Lashandria.
Yes, hello, how you doing?
All right.
I just want to say this was amazing and I really learned some information, but I just wanted to see if my understanding was correct. But I know that section 1983 may not be used to hold federal officials liable or so, but and I do feel that this defense immunity, it protects the state, from anybody that feels that they have their rights violated. But it's a difference in a similarity in the requirements, correct? Like when you prevail in filing a suit, the test standard of official immunity is like the good faith element or whatever, and the 4 elements of qualified immunity is like the person and the color of law of every person and right must be violated. Now, if that's the case, do the test of standard really need to be evaluated, and the 4 elements in the quality immunity need to be evaluated? Because if that's the case, people's rights is still being violated, period, regardless, even if it is proved that the government has wronged an individual. That's what I wanted to say.
Could you ask the question again? Because I just want to be
I
clear.
was saying, does the test standard of official immunity and then the 4 elements of qualified immunity that protects individuals need to be reevaluated? Because if that's the case, because they stated the test standard of immunity is in good faith.
Mhm.
Sometimes we wouldn't know of the good faith, because if it wasn't for videos, we wouldn't know if the police officer was acting in good faith. We only have to go out by word or other police officers around of seeing what had happened. So what I'm asking, do the test of standard need to be evaluated, and the 4 elements of the qualified immunity need to be evaluated?
I definitely think that qualified immunity and absolute immunity need to be evaluated in the sense of should they exist at all.
Correct.
Which I think, definitely should be limited. Qualified immunity at one point was a good faith exception. Ever since then, it's morphed into something far grander. In essence, you have to find a case that's almost directly on point that's happened before. Yes, in order to win on the qualified immunity point. But I think absolute immunity and qualified immunity are simply additional mechanisms that the Supreme Court has erected to protect government officials from accountability for wrongdoing. And so if they should exist at all, then I think they definitely need to be reevaluated.
Thank you.
Mm-hmm.
Lee, Leo, you're back up.
Hey, a follow-up question. So now there is, so in New York, the state legislature now has passed a law that I think abolished qualified immunity for police officers. I think that just happened a couple months ago. Do you see there will be a wave from progressive state legislatures to pass similar state legislation to limit or abolish absolute immunity for prosecutors? And do you think it's going to be much, I think really it's going to be much harder to push through compared to the abolishment of qualified immunity. Do you think there is sort of like a class situation going on that, oh, police are non-lawyers, and then judges, prosecutors, we are lawyers, we don't do the same thing to our own kind of thing going on? What is your take on that?
Generally speaking, it's been harder to put in place measures holding prosecutors accountable than it is with police. There was a prosecutorial bill that was passed in New York, and a court struck it down as unconstitutional. And this was, of course, after prosecutors mobilized and did their best to try and prevent it from getting passed. And then when it got passed, in essence, shooting it down. I think politics plays a big role. I mean, the prosecutor's office enjoys broad positive support and appeal within society. And so holding prosecutors accountable is a harder sell, which is part of the reason why I said that the information about prosecutorial misconduct, and more so the consequences, the real world consequences of prosecutorial misconduct, need to be put out there and publicized. I think also the situation comes down with, I think state by state, great. But there are some states like New York that at the very least pretends to be inclined towards criminal justice and reform. And then you have states like Texas and other places where, a law like that is just never going to happen. So I think state by state approaches are, if a state wants to do something about it, great. But that by itself is not sufficient, because for those who live in states where that's not a priority, then they're pretty much without a remedy.
Thank you.
Tasha, I see your hand. Sorry.
I think you're
muted. Your mic is on, but we can't hear you.
You can put headphones in.
Maybe, okay. While she's working that out, Zamir, will you go up a slide quickly to your, okay. Tasha, are you talking again? I can tell you're talking, but we still can't hear you. If you want to pop your question or comment in the chat and we read it out loud.
Just gonna... Maybe log in, yeah. Log out, log back in.
Maybe.
Yeah.
Yeah. I want to give her the shot to log back in before I go, but anyone else before I? So there's this number 4. You have this creating a deterrence effect. Can you tell me what your thoughts were on that again? Because I had one. I want to make sure you didn't already mention it.
So I think one of the things I want to do is have something that deters prosecutors from from engaging in prosecutorial misconduct, in individual deterrence. The problem with creating an effective deterrence is the fact that states indemnify police officers, and they would likely indemnify prosecutors too. And so it's not coming out of the prosecutor's pocket. And so it's no harm for them. And then if you take away indemnification for prosecutors, just like taking away for police officers, then you're removing the incentive to sue, because the whole reason a lawyer is going to sue is to try and get money, particularly if lawyers are working on contingency. So trying to think of a way to create a deterrence effect for prosecutors, individual prosecutors, right, and prosecutors' offices while at the same time not removing the incentive
to sue in the first
to
place.
sue.
Right. Okay. So I read that a little bit differently, but I'm wondering if, and we'll take Tasha in just a second, if there's another mechanism here. It doesn't necessarily mean it's not necessarily, it's the political pressure, right? So if you participate in egregious prosecutorial misconduct, like the teeth of this becomes something like the same issue with fruit of the poisonous tree type things, even though that's convoluted now too, is that it's an automatic release. There's no trial, there's no additional trial, there's none of that. Your kind of punishment is these defendants whose constitutional rights are violated because of prosecutorial misconduct, the automatically released, no question. That's a harder, I mean, it's still a hard sell, it's a political issue, but if it works, it's also political pressure on the prosecutor who continues to engage in misconduct, right? Because if they continue to have defendants that are released because they're participating in misconduct, either by withholding evidence, making decisions, stacking charges, making decisions out of racial animus and all of those things, there's no question anymore about your intent and I know that's covered in the paper, but I wondered about
that as a
that
possibility.
as a because it's literal. It's almost like you're taking advantage of the political pressure to.
Well, I mean, I don't really see, like, that's not really different from the status quo, because if prosecutorial misconduct is discovered and it's of the type to reverse a criminal conviction, then the person is going to be freed.
But it doesn't always feel affirmative, if that makes sense. Like it takes work for that to be the.
Well, yeah, because it has to be found.
Exactly.
So, a prosecutor who does slimy stuff is not going to come out with it. So, I think it's going to take work one way or the other. If you have someone who's not going to follow the law, then they're going to take steps to cover it up. And so, the person being released, that's great. But again, it doesn't really do anything for the harm that they suffered as a result of the misconduct.
Tasha, can we hear you now? Can you see if we can hear you now?
No. Why?
What is happening? Still can't hear you. On your where you see your mic and it says select a microphone, can you make sure it's your earphones? So there's a little caret next to your mic at the bottom. It's an upside down V, and then you should have the option to select your speaker and select a microphone, and they're probably going to be two different things. So for your microphone, will you pick your earphones? Can you pick it? Okay, so now we can kind of hear you. Now you have to raise your volume up. Now I know it's there.
You said you could hear her?
I heard a little bit when she picked her her mic up. Like her computer is just not trying to hear her
cooperating today.
Yeah, Professor Henry, you're still muted too.
Hi, I'll just talk until Tasha gets it together. The other thing I was thinking about is just, one of the things that Imbler sort of threw out there into the mix is, well, we don't need to have prosecutors amenable to suit because they can be held accountable through disciplinary sanctions. And I think, I was thinking when Kenitra was mentioning, her like what you were just saying, it's the other piece of it, right? Like, if prosecutors were actually being held professionally accountable, which they are clearly not anywhere in the entire country, but were there to be a robust professional disciplinary program, that also sort of helps us with this whole like negligent versus deliberate versus intentional, it kind of gets, and obviously somebody loses their law license and is disbarred. That's kind of a big deal. And that would also have that deterrent effect that you're talking about. But again, it's one of those pie in the sky things, because, you know, even the act of getting a prosecutor referred to a disciplinary committee, let alone having the committee verify that there was some kind of, you know, misconduct, it never happens. But that's, you know, I think that's also part of this conversation. Like, we wouldn't almost, I mean, suing is very helpful to provide compensation to those that are harmed, but there are other mechanisms that in theory could also be very powerful were they, you know, ever enforced.
I agree with that. And, you know, I've always taken a position when asked that what I'm proposing does not have to be, you know, exclusive. So if the states would like to make their disciplinary boards effective, right on. If they want to start prosecuting prosecutors, okay. Whatever you want to do, fine. Just figure something out to address the problem. But I think, as you know, currently as it is, it's not effective.
I'm all for disbarment. It's like, but that might be a little harsh for some people.
I mean, it depends on what it is. You know, if you're talking a clear Brady violation, you intentionally hid evidence, you suborn perjury, you know, the type of things that an officer of the law should not be doing, then yes, you should be held accountable.
You know, and it's fascinating, even getting information about allegations of misconduct, the whole thing is shrouded in secrecy. So, you know, when you've got prosecutors who routinely engage in Brady violations, or, you know, you relying on informants they should know or lying or whatever it is that they're doing, you know, it's astonishing just how difficult it is to even get information about accusations or allegations about specific individual prosecutors. And so it's all part of this, like how this is, again, what I've been thinking a lot about is just what does it mean to hold a prosecutor accountable? Like what does that look like? Because it's so complicated, and there's so many systems that are there to protect them. It's not just that you can't sue them, it's that you can't do anything. And I mean, even prosecuting prosecutors, like, please, who's gonna, you know, you're asking the chicken to, I mean, the hen to, you know what I'm talking about, the wolf to, I need more
Between 1871 and 2011, there was one recorded prosecution of a prosecutor, and that happened in 1981. So 5 years after Imbler was decided. So it pretty much had never been used. I mean, I think to speak to the question of what does prosecutorial accountability looks like, it looks like a system where prosecutors are hesitant about doing whatever it takes to win, for fear that certain types of behavior are going to have you held, you know, punished in essence for it. I'm going to read the question in the chat. So. I think that's a fabulous question. I think, again, it comes to publicizing kind of the issues and kind of what's going on. I think specifically with respect to with the officer immunity, as much as I hate to say it, you know, it's just rife with examples. I read a case very recently where in Texas, the police had kneeled on somebody's back for about 14 minutes, their back and their neck for 14 minutes. They died. And strangely enough, the Fifth Circuit actually reversed a granting of qualified immunity and allowed the lawsuit to go forward. But I think publicizing these stories and making them so, you know, they're in the conscious mainstream. And, you know, if you're human, then this should bother you. And you should want to do something about it. And so I think really generating that momentum again, it will only happen through, you know, these stories being known and being strategic about the story, because you want it to be, you know, out there enough so that people are galvanized, but not so much where people are desensitized to it.
That point about desensitization is a big one that I've been thinking about. But I do want to point out that, you know, who prosecutes the prosecutors. I do want to point out that I remember a model, and it's very recent, here in Texas, on a case. I may be wrong about which case it is, so I'm not going to say it. I think I am wrong about which case. But basically, Dallas County, you couldn't trust the prosecutor's office to make a decision against an off-duty police officer to try him, and so they have a special prosecutor. The special prosecutor was a former DA, but now a practicing defense attorney. And so the idea was we won't even have, because there's some questions about the objectivity of the DA's office. The person who will try the case, who will bring the case to grand jury and try it, it will be an actual special prosecutor who is now currently a practicing defense attorney. And I wonder if that model works for prosecuting prosecutors. So it worked because the defendant in that case was a police officer. And again, because Dallas County had not prosecuted a police officer in that role before, there was a question about their ability to do it. And so special prosecutor did it. And what that model might look like in this space. If you think about like these other standards of proof or how to sue a prosecutor, maybe other prosecutors are the ones that are doing it. It's literal defenders in this space, right? Or some mechanism for that.
Yeah, I mean, I definitely think that can happen. I think the interesting thing with respect to civil rights, federal legislation, is that it would be federal prosecutors doing it. So it's not necessarily the symbiotic relationship to the same extent of if a federal prosecutor is prosecuting a state prosecutor, then, doesn't necessarily have the same allegiances. But it still just doesn't happen. But I think something like that could possibly work. Again, what I proposed in the article is not exclusive. So whatever works, I'm for that.
Any last minute thoughts? We've got 2 minutes before technically the end of this presentation. All right, I don't see any other hands, but I want to thank everyone for attending this afternoon, for taking some time out of your afternoon to join us. We have an event next week. The Deason Center is hosting a webinar entitled Solving the Initial Appearance Crisis, and we'll be discussing our efforts at looking at what each state is doing around assigning counsel or providing counsel at initial appearance hearings, and what that means, and even the length of time between arrest and initial appearance. So that webinar will feature Malia Brink, who's cited in Professor Vindan's paper, our director, Professor Pamela Metzger, one of our policy attorneys, Jachen Yu, and they'll be discussing their work around this crisis, and it will have CLE credit. So I'm going to post the link in the chat so that you can register if you would like to attend next week. It's Thursday at 2:00. And also I'll post a separate link for the rest of the lineup for the CJR workshops this semester. We'll host Sean Hill from OSU Moritz School of Law in October, and his talk will be on compromising the social contract, which could be seen as a follow-up to this conversation too. And then in November, we'll host Professor Miguel de Figueiredo from UConn Law, and he will discuss unwarranted warrants. So he'll be talking about Fourth Amendment jurisprudence. So again, I will post the link to the registration link to next week's webinar, and I will post the link to the remainder of our fall events for out of the Deason Center for the fall. We have an amazing lineup of engagement events, so I really hope to see some of you there. And almost all of them, except for our workshops, usually will include CLE credit. So I'm going to leave the window open so you guys can grab the links. And if you have any questions,